Hi. Recently, Supreme Court gave a decision against the builder developer. I will explain it in a simple language. If the builder enters an agreement with the purchaser, claiming that he will pay a rent, approximate rent, if he defaults in delivering possession, and if the purchaser defaults in making a payment, whatever the amount that is to be paid to purchase an apartment, if the purchaser defaults, he will be liable to pay 18% per annum or whatever may be the rate of interest. If these two terms are there in the agreement. Now, obviously, the agreement will be in the favor of the builder, because the bank rate of interest that is applied to the loan that is taken by the purchaser will always be higher than the rent that is promised to be paid by the builder in default of possession. To understand the Supreme Court judgment in a simple language, we will take the help of this illustration. Let us assume that you have taken a bank loan above 1 crore to purchase an apartment, and every month 1 lakh interest is being loaded to your loan by the bank. And the rent that was promised by the builder in default of giving possession within the due date is approximately around 50,000. If this is the agreement that is entered with the purchaser by the builder, then builder is always at an advantage. By default, builder will be at advantage. Therefore, the matter reached Supreme Court on behalf of the purchaser, and Supreme Court delivered a decision which is in the description box. Kindly go through it. In favor of the purchaser. Supreme Court went beyond the agreement. Though it is already in the contract law, Supreme Court once again reiterated and went beyond the agreement and gave an order in favor of the purchaser, saying that purchaser is entitled to the loss or the deficit in the real time, notwithstanding the loss may be against the contract, against the terms of the contract. Now, in the illustration what we have taken, the loss that is crystallized as per the agreement itself is 50,000. The builder need not pay more than 50,000 per month because interest is 1 lakh. He promised the rent of 50,000. But the deficit loss that is incurred to the purchaser is another 50,000. There is no need for the builder to pay another 50,000 per month if the agreement is taken into force. The agreement is in favor of the builder. But applying the principles of the natural justice, purchaser is at loss. Therefore, Supreme Court took a decision in favor of the purchaser. But this is totally against the builder. So now what is the remedy for the builder? So this video is for builders or developers. So the only possible remedy available for the builder or the developer is to enter an oral agreement wherein builder should not commit the due date. Obviously, when due date is not committed, the rent payable will also be not committed. That question itself will not arise. And the purchaser also will not commit for the default in payments, because it is an oral agreement on a friendly terms. The oral agreement, based on the oral agreement, the purchase will happen. Now, the situation is totally fluid state. The other is written agreement. Every time oral agreement may not be possible. If it is a written agreement, these two terms should not be there in the written agreement. Then the agreement will be in balance. Purchaser will not be liable to pay some X amount of interest if he defaults in payment, and the builder will also not liable to pay any rent if he defaults in delivery of possession. If these two conditions are not there in the agreement, or if approximities are attributed to these terms in the agreement, not exact terms, approximatives, then that agreement has balance. If that agreement is taken to the court will apply principles of natural justice. So that is left to the courts. Now it becomes a court-made agreement, court-made law. So that is, to some extent, builder will be saved, because that agreement, that clause was not accepted by the builder or the purchaser. So they left those clauses in the fluid state. The decision that went to Supreme Court, it was a DLF company there. They crystallized the clauses by exact terms. That is, the purchaser has to pay X amount of interest if he defaults, and the builder has to pay X amount of rent if he defaults in delivery of possession. So there were the exact terms in the real time. But here, if you could enter an agreement with these two terms in the fluid state, not in a solid state, then builder can save from burning his pocket to a little extent. Otherwise, builder has no case. Whatever the loss that is incurred by the purchaser, builder has to pay. That is what the Supreme Court decision declared. Of course, purchaser has to file a consumer complaint. Here also, purchaser will file a consumer complaint, but because it is in the fluid state, court can make some balance there. Court can play the game to some extent. Okay, thank you. Thanks for watching. If you have any doubts, kindly comment.